having fought the fight already for 6 years, having asked something as simple as to be served a cup of coffee or a glass of water and have something to eat, been told unequivocally and numerous times no. But still they said, you know, it's not right. I should be treated like everybody else. And you imagine the courage. Now, no doubt, when Hugh Burnett passed around his petition in the late 40s, having served his country and fought for freedom, he was told that he was being a nuisance. And no doubt, when he sat in the restaurant and asked to be served, it was suggested that he was a nuisance. And no doubt that when he returned with other colleagues and wanted nothing more than to be served, he was told, or it was thought, that he was a nuisance. But it was his courage that broke the barrier. It was his courage that achieved something as enormous, as magnificent, and yet as simple as the right to be served a cup of coffee. Well, you've heard about the Woolworth sit-ins in the States, no doubt. But in fact, leaders right here in Ontario resulted in changes in legislation. Changes brought in by the then progressive conservative Premier, Leslie Frost. It was a determination by people who are known in the community, such as Newton Rowell and Boralaskin. Determination and courage by those who were not unlike anybody else. They worked hard. Hugh Burnett was a carpenter. They worked hard. But they had the courage to stand up and fight in a nonviolent way for what they believed in. What we take for granted today as the foundation of our society. And why do people come to Ontario today? Because they know that human rights and the respect for them is not just the fashion of the moment. It's not the fashion of the government of the day alone. It's not a matter of one piece of legislation. Because, of course, governments change. Not too quickly, one hopes. But they do. And legislation can change. When Leslie Frost combined different pieces of legislation and brought in the Human Rights Code in 1962, it was a progressive conservative premier that did that. And he not only brought in the statement of rights in a specific piece of legislation, but he brought in the enforcement mechanism for those rights. Because rights without a remedy, rights without enforcement, are not overly helpful. So he brought in the enforcement mechanism, all based on the courage of individuals, not institutions, individuals. And that system has remained, the genesis of that has effectively remained throughout the decades. Undisturbed, our determination to state those fundamental rights in a piece of legislation known as the Human Rights Code, and our determination to have a specific and specialized enforcement mechanism, which not only ensures they will be dealt with as effectively as they should be, but ensures that the focus will always be on their importance. It remained through Leslie Frost. It remained through John Robards. It remained through Bill Davis and Frank Miller and David Peterson and Bob Ray and Mike Harris and Dalton McGuinty. Every political party, every premier, nobody has suggested that we should get rid of that. No premier has suggested that. And no doubt and no doubt that when people advocate for their rights, they're thought of as a nuisance. No doubt they are from time to time. Of course, you're challenging the established order of things. So can we sit here and say, well, you know, that battle was fought by Hugh Burnett, and we can just sort of get up and walk away? We can turn our attention to something else. Can we say that there's no longer a need to be vigilant? You know, there was a study not too long ago, and let me just stand here as put my advocate's hat on and say, I don't have to comment on whether the study is 100% accurate or not. Just, there was a study that suggested that people who apply for accommodation, for rental, housing accommodation, are not equally treated. And the treatment, the differential treatment, can be based on whether they look like me or whether they don't. Now, there was a study, and I didn't tell you when the study was, and you're probably thinking of the one that was reported just a week or so ago in the paper, virtually identical to one that was done in 1962. It doesn't mean that we are worse as a society. No, indeed, in an infinite number of ways, we are much better. We are much stronger. But it does mean that not for a moment can you step back and be content. The strength of the society in which we live is not simply its accomplishment, its ability to house people and have people live together from all over the world, speaking a whole collection of languages with every religion represented. That's not it. That's not enough. It is the strength of Ontario, is its determination that we won't rest, and the knowledge of anyone who wishes to challenge those rights that we won't rest. We will not let any form of discrimination go unchallenged. We will not let any form of differential treatment go unquestioned. That's the strength of a society. Not simply its accomplishment, but its determination to continue to maintain and improve. Our determination, our shared determination, our individual and institutional determination to strive for the ideal. That is at the foundation, the core of Ontario. That is what premiers of every party have given expression to. That is what institutions have given expression to. But most importantly, that's what every Ontarian has given expression to over the years and over the decades. And, of course, it can be a nuisance. It can be a nuisance. Now, we have an enforcement of our rights, an enforcement mechanism of our rights, which is essential to their achievement. Not only do we focus on the rights, but we say you must enforce them as well. We must enforce them because discrimination will be found, unfortunately, whether it's anti-Semitism, Islamophobia, hate in different forms, stigmatization through people with mental health disabilities. It comes in many forms. But you must constantly enforce rights. And the enforcement mechanism in Ontario has been a specialized one. Why? To give it focus and to ensure they're dealt with as effectively as possible. And just last year, a year ago, we brought in an improved enforcement mechanism. You always have to improve. And so now we have a three-part enforcement mechanism. One is the tribunal, the Human Rights Tribunal, which has the special knowledge to deal with cases openly and effectively. Now, of course, as with any tribunal, as with any court, there will be a whole collection of cases before the tribunal. I mean, the purpose of a tribunal, a court, any adjudicative body is to make a decision. Make a decision because two parties can't.